Court does call the case of the people versus Kamar Reed.
Ashley Lonnie for the people.
This is how many court dockets begin. Quick, procedural, almost casual, but don't let that tone fool you. What we're watching unfold here is the front door of the criminal justice system where lives can change in minutes. Kamar Reed is stepping into court for an OWI first offense, and even though this is labeled no crash, no prior, the stakes are real. An OWI charge follows you on your record, your license, your insurance, and sometimes your employment. Right from the opening, notice how efficiently Judge Simpson runs this courtroom. No theatrics, no wasted time. This is a judge who expects preparation and clarity from both sides. And for viewers at home, this is where things often feel deceptively calm, because arraignments aren't about guilt yet. They're about control. Who gets freedom? Who gets restrictions? Who gets trust? As this case unfolds, pay attention to how much discretion a judge actually has, even at this early stage. Bond conditions, travel permissions, alcohol monitoring, none of that is automatic. It's all judgment calls. And those judgment calls are going to matter a lot in just a few moments.
Morning, Your Honor. Dan Garrett on behalf of Ms. Reed. She's stepping forward.
Good morning.
Good morning, Your Honor. Kamar Reed.
For arraignment, we would waive reading and stand mute, please.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea.
I'm ultimately asking for another pretrial mid-June if possible due to my client's requested travel, which I'll address in a second, as well as travel I have.
All right. Pretrial in this matter then will be June 18th, 2025, 9 a.m. As to bond.
Here, this is an alleged OWI first offense. There's no crash. Alleged BAC .099. We are requesting
099.
Preferably soberly. This matter. No priors, Your Honor.
No crash.
No crash.
All right. It's a traffic stop. Is that
Traffic stop for no headlights. I think of note at the scene, it was a 08. And as it relates to any testing, I do want to address travel when Your Honor's ready.
all right? Set her bond at a $10,000 personal recognizance. All other standard conditions, including no assaultive behavior or possession of any weapons. There should be no use of alcohol, recreational marijuana, or any illegal drug. Given the BAC level, I'm not going to place her on a testing device at this point.
Your Honor, I appreciate that. One of the things we added it. Let me say this a different way. She's asking to go to Arizona today, leaving in like 2 hours. I was going to adjourn, but Ms. Lundy and I agreed to just do that today. So she's asking permission to.
If I said no, what happens?
She's staying right here with us. That's what happens.
Why are you going to Arizona?
My cousin's graduating high school.
Family that graduates. See, Karen knew that.
I did know that.
Yeah, and it's gonna. How long? Today through
The 31st.
the 31st. It's a
Yes.
long graduation.
And family reunion.
Leave that out. All
Your
right.
Honor, one thing I did want to mention, but I neglected to, I apologize for the interruption, is that the defendant at the time of the offense was 20 years old. She had not yet
Oh,
21.
she
So
has not yet turned 21.
that's correct.
Okay, that changes. Thank you.
These three words, that changes, carry enormous weight. Everything shifts the moment the court learns the defendant was under 21 at the time of the offense. Underage alcohol offenses trigger heightened concern, especially in OWI cases. The judge immediately recalibrates. Now the court orders community corrections and places her on a sober device. That's not punishment, it's prevention. The court is saying, if I'm going to let you travel, I need accountability. This is how judges balance freedom with public safety. Also notice how quickly this happens. No argument, no delay. The court adapts in real time based on facts. This is why accuracy matters in court. Miss one detail and your conditions can change instantly. For viewers, this is a textbook example of why age matters legally. The same behavior carries different consequences depending on who you are.
I apologize for the interruption.
All right. So I will indicate that the defendant may travel to Arizona today. I am going to order community corrections. I am going to order that she be placed on a sober device, given that there's an age issue.
Could she go right?
She can go right now.
Good.
They're usually watching, but if they have a problem, they can call in.
Sounds good.
Usually people don't run over there asking to be put on a device. So,
Get her over there right now. Thank you.
all right.
Attorney.
Thank you.
Thank you.
Have fun in Arizona. It's hot.
Yes.
Court calls the case, People versus Aaron Salazar.
Ashley Lonnie for the people.
Morning, Your Honor. David Chan, on behalf of Aaron Salazar.
Yeah, Your Honor.
We do, Your Honor, we do have a plea in this matter in return for the super drunk charge being dismissed. My client will plead to OWI first.
That's correct, Your Honor. The 93-day misdemeanor, $100 to $500 fine, 6 points from his license and various other Secretary of State sanctions. Contrary to 257-6251A, will dismiss the OWI high VAC. There had recently been, not a violation, but a progress report cautioning the defendant to remain compliant with his SoberLink device. Mr. Shan had shared with me some of the explanation as to why there was that late/miss test. So I'm satisfied with that explanation and ready to move forward with this plea should the court accept it.
All right. And that's a correct statement of the plea.
Yes, it is, Your Honor.
All right.
He cleans residential houses and he takes SoberLink with him. And he left it at a residential house that he cleaned and then had to go back and get the owner to get the SoberLink out of the residential house so he could do the testing. So that is what happened.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, yes.
State your name, please.
Aaron Salazar.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days of jail, a $500 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary.
This is called a plea colloquy, and it's one of the most important protections for defendants. The judge is methodically confirming that the plea is knowing, voluntary, and intelligent. This isn't just formality, it's to prevent future appeals claiming coercion or confusion. Notice how Judge Simpson slows down. He repeats questions, he checks comprehension. When defense counsel explains the sober device issue, the judge accepts the explanation, but only after ensuring it makes sense. This is also where courtroom tension can creep in. Judges take these moments seriously because once a plea is accepted, there's no rewind, no trial, no jury, no second chance. Engagement question? Have you ever noticed how many times judges ask the same question in different ways? That repetition is intentional and protective.
The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
And understanding that, do you still wish to plead guilty?
Yes, I.
And to that charge, how do you plead?
Yes, I'm guilty.
You pleading guilty?
Guilty. Yeah.
All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
No trial.
Not right.
That's the stuff that we went through. Yeah.
You understand that you will not have a trial, sir.
I'm sorry. Boss.
Do you understand there'll be no trial?
Oh, yeah.
All right. You signed an advice of rights form today, is that correct?
Mm-hmm. Yes. Sir.
All right. Do you have any questions regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that you're giving up those rights as well as all the rights on that form.
You understand these?
Yeah, I understand.
All right. You understand you're giving up those rights.
Yeah, you're waiving those. You're giving them up.
Yeah.
Okay. Is he understanding me?
Yes,
Because I've got to make sure that he does.
Yes, he does. And that's why I'm slowing down because you speak really quickly and he does.
So that's the second insult Shane has given my court today. The first one when I wasn't out here, but was reported to me.
I did that.
No,
that is
you
not
said
an
it, and
insult.
I know you said it. Now you just did that. Now, that first one was about how hard I think I work my staff.
It was an
And
honest.
then this
honest
was just a
statement.
direct attack on me.
This is one of those moments that makes courtroom footage fascinating. Judge Simpson pauses the legal process to address tone and respect. He feels slighted, and he says it out loud. But here's the key. He doesn't retaliate. He acknowledges the moment, clarifies it, and moves on. That's professionalism. Judges are human, but they're also guardians of fairness. Addressing perceived disrespect openly prevents it from festering beneath the surface. This moment also reminds attorneys of something critical. Words matter. How you explain your client's comprehension, or lack thereof, can sound like criticism if you're not careful. Audience question. Do you think judges should call this out in real time or ignore it and move on?
All right. So, no, I won't hold that against you. All right. But is he understanding?
Yes, he is.
All right. So you understand you're not going to have a trial. You're waiving all of the rights that are on this form.
I understand.
All right. You understand that you're giving up your right to appeal of right.
Yeah, I understand.
All right. Are you on probation or parole?
Yeah. I understand.
That's beyond bond.
Okay.
Yeah.
Are you under the jurisdiction of any other court?
No,
All right. Have you ever been to prison for longer than a year?
okay.
Have you ever been to prison?
Yeah,
Have you been to prison
the present where?
in the United States? Have you ever been to prison? Not jail, prison.
Yeah, yeah, yeah.
Okay. Council approach, record should reflect that it had a bench conference with council. I'm going to stop the plea at this time. I'm going to adjourn this matter out June 4th, 2025, 9 a.m.
And just like that, the plea stops. This is rare and it's important. Something surfaced during questioning that raised concern. We don't hear the bench conference details, but that's intentional. Bench conferences protect sensitive information while allowing candid discussion. By stopping the plea, Judge Simpson is preventing a potential legal problem down the line. Maybe there's confusion, maybe prior history, maybe jurisdictional issues. Whatever it is, the court chooses caution over speed. This is a reminder that judges are not plea rubber stamps. Even agreed-upon deals can be paused or rejected if something doesn't sit right. For viewers, this is a powerful takeaway. Court is not just about outcomes, it's about process. And when the process isn't clean, everything stops.
And we'll take care of submission. All right.
Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Sarah Orr.
Testimony for the people.
Sherilyn Foster Tucker on behalf of Sarah Orr.
Or Your Honor.
Thank you. All right. What, briefly, yes. In fact, we've had a bench conference in this case.
Yes, Your Honor, and there has been an offer extended to the defendant to plead to an added count of failure to report $1,000 damage accident, 90-day misdemeanor, $100 fine, and 0 points, contrary to MCL 257622. In exchange for that plea, count 1 will be dismissed.
That is correct, Your Honor. And Ms. Orr does wish to accept that offer today. And I have handed the court an advice of rights form.
May I have her sworn, please?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Sarah Orr.
No. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of failure to report an accident. It's damage over $1,000. That's a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Yes.
All right. Understanding that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You
Sorry.
signed an advice of rights form. Is that correct?
Yes, I did.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your
You
Honor.
understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
Because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On May 22nd, 2024, at the location of Moon Road near Michigan Avenue, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
All right. Were you involved in an accident?
Yes, Your Honor.
What happened?
So I was in the yield lane or the merge lane, whatever it's called. And the other guy was in the through lane and we were at the red light. And when we were driving through, I got in front of him and then he got into the turn in lane. And then he says he was going to turn, but I don't think he was because of the way the damage is, he hit the front of my car and the front of his car. So he was trying to get back in front of me.
You're
But then
heading,
we collect.
you're heading north.
Correct.
You were heading toward Ann Arbor.
No, away.
You were heading away from
So
Ann Arbor.
south.
So you were coming past the Walmart,
Yes,
heading out.
right. Where State Street turns into Moon Road.
Yeah.
Yeah.
Okay. All right. And so you had this collision. Did you immediately stop your vehicle?
I did not. I was a little scared, so I did not.
Okay, you didn't stop. Did you immediately report that to the nearest and most convenient police
I did
station?
not.
You did not. Would you dispute that the aggregate amount of damage that can include repair cost was in excess of $1,000?
For mine or for his?
Total.
You obviously don't know how much his vehicle.
Right, correct.
But would you dispute that if he says it was more than 1,000, would you dispute that?
I didn't see the damage, so I don't know.
We can stipulate that it
You'll
was over
stipulate
1,000.
the damage, total amount of damage to both vehicles was in excess of 1,000, including repair costs. You'll stipulate to
Yes.
that, counsel. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
This is a clean plea resolution. 1 count dismissed, 1 accepted, sentencing deferred. What stands out is the court's focus on process compliance. Judge Simpson explicitly asks whether court rules were followed before accepting the plea. That's not filler, that's appellate armor. Another subtle but important detail. No restitution expected because insurance covered everything. That matters. Restitution can dramatically affect sentencing outcomes and post-conviction obligations. When insurance resolves damages, courts often narrow punishment to fines, probation, or monitoring rather than financial recovery. This case flows smoothly because everyone is prepared. When preparation meets honesty, court moves fast.
Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
June 25th.
June 25th, 2025, 9 a.m.
And Your Honor, I do not expect a restitution. I do believe the insurance covered everything.
Covered everything. Okay, fantastic. All right. Thank you. All right, bond will continue. You'll stop down at probation on the way out. Just
Okay.
Check out. All right.
Okay, thank
Thank
you.
you, Your Honor.
Thank you. Court does call the case, people versus Michael Klustra.
Ashley Lonnie for the people.
Morning, Your Honor. Uwe Dahlswithen on behalf of Mr. Klustra, standing to my right. Mike, please state your name for the judge.
Michael Klustra. All right.
We have an adjourned plea trial, had discussions with Ms. Landi. May counsel approach, please.
Yes, briefly,
Thank you.
folks.
Today's the day.
I got a whole lot of cases.
Thank you, Your Honor. We're looking for another adjournment if we could. I don't know how long Ms. Landi thinks it might need to be.
I will accommodate the defense counsel schedule.
I'll do the 18th, 2025 at 9 a.m. If you think what you're working on is going to take longer than let the court know, we'll figure that out.
Thank you.
Very
All
good.
right, thank you. Court does call the case, people versus Gabriel Boyd.
Ashley Lonnie for the people.
Good morning, Judge. Rita Spahich on behalf of Ms. Gabrielle Boyd. Judge, I had a very lengthy conversation with my client last night. I am quite shocked she's not here this morning and very, very surprised. I'm hoping that she's okay. So I'm just asking if you could just pass it for a moment. I've been trying to get in touch with her, but
Absences in court immediately raise alarms. When even defense counsel is surprised, that tension is real. Judges read these moments carefully. Is this avoidance? An emergency? A breakdown in communication? Judge Simpson shows restraint by passing the case, not issuing a warrant immediately. That's discretion again. Attendance matters, but context matters more. Courts balance enforcement with fairness, especially when a defendant has a history of appearing. Engagement question. Should courts be quicker to issue warrants when defendants miss hearings, or is patience the fairer approach?
this is quite shocking. She's been here every single time, so I hope. that
So it was a good conversation?
Yes, very good
Okay, all
conversation.
right. I don't know, maybe you were yelling at her.
No, it was not anything bad. That's
No,
why I'm a little
okay.
bit, I'm a little bit worried about it. If you could just pass it.
I'll pass.
Thank you. I appreciate it.
Court does call the case, people versus Rebecca Dilworth.
Ashley Lonnie for the people.
On behalf of Ms. Dilworth, not sure if she's logged into Zoom yet, Judge.
And Your Honor, I have prepared a nollie in this case. If she's not, I don't know if the court's received it yet.
I don't have Miss Dilworth.
With the case, Judge, we are asking that the court excuse her presence. We are expecting a dismissal from the people anyway.
You're moving to dismiss.
That's fine. Yeah, paperwork's on its way. It should be here anytime now.
Okay.
No,
Thank you, Judge.
case is dismissed. Thank you. Court does call the case of the people versus Natasha Olmos.
Ashley Lonnie for the people.
Kyle Burdell on behalf of Natasha Olmos, who's approaching the podium. And Ms. Olmos, please state your name for the record.
Hi, good morning, Natasha Olmos.
Thank you. What are we doing?
So, Your Honor, we are currently in plea negotiations. I believe we can come to a resolution soon. We are asking for an adjournment in this matter. I believe the court was giving June 4th or the 18th.
Yes,
I'd ask for the 18th. I'm not available on the 4th.
people picking their dates again. June 18th, 2025, 9 a.m. Bond continued.
And if we maybe heard us to bond.
Yes.
Thank
Go
you,
ahead.
Judge. So, Your Honor, Miss Olmos has been on a sober scram tether since the inception of this case. She's had no issues. There's been no positive tests, nothing with the tether. We are asking that.
Operating with an occupant less than 16.
Yes, Judge.
She'll remain on the tether, if that's what you're going to ask.
Thank you, Judge.
Thank you. Court does call the case of the people versus Arello Beavers.
Assistant Public Defender Natalie Pate on behalf of Mr. Beavers, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
I don't have him there either.
Your Honor, I did speak to him.
Arello Beavers, we have no response.
Your Honor, I did speak to him and did anticipate that he would be here today. I don't have an explanation for his failure to appear. For the record, I'd request an adjournment.
Beavers? No, not here. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege. That warrant will issue immediately.
Here's the flip side of discretion. Unlike the previous case, this absence leads to an immediate bench warrant. Why? Pattern, explanation, credibility, or lack of it. Courts don't punish absence emotionally. They respond to risk. A $5,000 warrant with 10% privilege means the defendant now has a financial barrier standing between freedom and custody. This escalates the case instantly. Missed court dates compound legal trouble faster than almost anything else. For viewers, this is why lawyers stress attendance relentlessly. One missed hearing can undo months of progress.
Thank you, Your Honor.
Court does call the cases of the people versus Byron Blair.
Assistant Public Defender Natalie Pate on behalf of Mr. Blair, Your Honor, who I do not believe is present.
Excuse me.
Oh, Cedric Blair.
Hello, who are you? That's Cedric Blair. That's not Byron.
I believe so, Your Honor, based on his voice. So as to Mr. Byron Blair, Your Honor, he does not have a working phone number. He is usually a resident of the Delana Center. I did send him an email and I did not hear back. To that end, I do not have an explanation for his failure to appear, and for the record, would request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege on it. Thank you. Court does call the case of the people versus Cedric Blair.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cedric Blair, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Cedric Blair.
All right, what are we doing?
Thank you, Your Honor. There is a resolution in this matter to which my client will be pleading no contest to the added count of retail fraud in the third degree, and in exchange, count one will be dismissed.
That's correct, Your Honor. That is contrary to MCL 7503560 as in dog 4, 93 senior $500 fine or trouble amount.
Sir, please raise your right hand. You'll need to unmute now, Mr. Blair.
I was trying to.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name again for the record.
Cedric Blair.
All right, you can put your hand down. Mr. Blair, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
If I may, Your Honor.
Or plead no contest, I'm sorry.
Thank you. That's what I was just about to say. Excuse me, Your Honor.
All right. Do you understand what a no contest plea is?
Yes.
This explanation is textbook and crucial. A no contest plea protects against civil liability while still allowing criminal sentencing. Judge Simpson explains it slowly, clearly, and twice. That's intentional. Defendants often think no contest means less serious. It doesn't. Sentencing treats it the same as guilty. The difference lives outside this courtroom, in potential lawsuits, restitution claims, or civil exposure. Audience question: if you were facing possible civil action, would you choose no contest even knowing the criminal outcome stays the same?
All right, 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand about it is it means that the court is going to treat you the same as though you had pled guilty for the purposes of sentencing. You understand that?
Yes.
Basis of no contest plea.
Potential civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes,
All right. You signed an advice of rights form, is that correct?
that's correct.
Any questions regarding any of those rights?
No, Your Honor.
You understand that your trial, you'll be giving up your trial rights, which are described in paragraph 5, as well as all of the rights that are contained on that form.
Yes,
You understand you're giving up your right to appeal of right. Are you on probation or parole?
no, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right. The court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-16486. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Before satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendants referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
June 25th at 9 a.m.
June 25th, 2025, 9 a.m. Bond will continue. I don't have probation. I do. All right. Bond will continue. Sir, wait on the line. We're going to put you into a breakout room with my probation department so we can start the sentencing process.
Excuse me. Hello?
Yes.
You said I'm just automatically on probation? I'm just curious.
I didn't say that.
Oh, okay. That's why I was asking, Your Honor. No disrespect.
All right, but my probation department will interview you and will make a determination. So you need to wait on the line. You'll go into a breakout room with my probation department so we can start the process.
This is an important clarification moment. Defendants frequently misunderstand probation status. Judge Simpson corrects the assumption immediately, without hostility. Probation interviews are evaluative, not automatic punishment. The court gathers background, risk factors, and compliance history before sentencing. This protects both the defendant and the public. This exchange shows why asking respectful questions matters. The defendant speaks up, the judge clarifies, and the record stays clean.
Okay.
Thank you.
Thank you, Mr. Blair.
Court calls the
Thank
case,
you.
People versus Candace Brooks.
Requesting to practice pursuant to
You
Michigan.
got to come closer to the microphone. This is your first time doing this, right?
Yes, Your Honor.
Okay, go ahead.
Okay.
Take your best shot.
Your Honor, Christina Barrick-Darian requesting permission to practice pursuant to Michigan Court Rule 8.120 under supervision of Assistant Prosecuting Attorney Ashley Londy.
I won't embarrass you by going through the series of questions. I did that the other day. I know where you're from, where you are, right? You're at Wayne State, right?
Yes.
Okay. Good school. You like Wayne State? No. You do? Okay, we'll let her practice. Permission to practice is granted.
Your Honor, Christina Barrick-Darian for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Brooks. Can you unmute and state your name for the record, please?
Candace Brooks.
Okay.
We are requesting an adjournment. Just want a little bit more time to talk to the people about a potential offer.
Hearing no objection, I'll adjourn this matter June 4th, 2025, 9 a.m. Court calls the case of the People versus Jason Brooks.
Absolutely, the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brooks. Oh, thanks. Please state your name.
Jason Brooks.
Thank you, sir.
Your Honor, I am requesting an adjournment. I was unable to speak with Mr. Brooks prior to today. I'll get updated contact information, just make sure we have the right number for him before he leaves the building.
All right, June 4th, 2025, 9 a.m.
Thank you.
Thank you, Mr. Brooks. Court calls the case of the People versus Zachary Burlett.
Ashley Londy for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burlett, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Zachary Burlett.
There he is. Okay.
Thank you, Your Honor. I have discussed this matter with the people, and it was my understanding that this was going to be a dismissal. Oh, sorry.
What did you say?
Just getting my notes pulled up, Your Honor.
Oh, okay.
One moment, I clear off my screens. That's correct, Your Honor. We are going to be dismissing this case.
Certainly no objection to that.
Case is dismissed. All right. Thank you, Mr. Burlett. Take care.
Have a good day.
Thank you, Mr. Burlett.
Court does call the case of the people versus Justin Goltowski.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Goltowski, who I do not believe is present, Your Honor.
He's in.
Oh, he's in Zoom. Perfect. So my message got to him.
State your name, sir.
Justin Goltowski.
Thank you.
Thank you, Your Honor.
You're probably gonna need an adjournment.
I am respectfully requesting an adjournment. I was able to speak to, I believe it was his roommate yesterday, so I'm glad the message got passed along. That is excellent news. But I do need to talk to Mr. Goltowski himself regarding his case, so I'd ask for an
June
adjournment.
4th, 2025, 9 a.m. All right, thank you, sir.
I got a phone number for you. It's for my attorney, if you don't mind.
What'd you say?
I have a new phone number for my attorney, if you don't
Okay,
mind.
I don't want you broadcasting it that way.
Okay.
So, you can call the clerk's office and give it, or let me give you the public defender's office number. Call them, give them your updated phone number, as well as, making sure that your email that they have is correct, and then you'll be all set.
Okay, yes. Thank you, Your Honor.
Thank you.
Thank you, sir. Thank you, Your Honor.
Cases of the people of the state of Michigan versus Jason David Allen, all 9 of his files.
Ashley Lonnie for the people in all matters.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Allen, who should be present via Zoom from Don Parm. Sir, can you please unmute and state your name for the court?
Jason Allen.
Thank you, Your Honor. There is a resolution of all 9 of these matters today, Your Honor. I don't know if Ms. Londi would prefer to put the resolution on the record, or I could do so.
This is the heavyweight segment of the docket. 9 cases, multiple retail fraud counts. The volume alone tells a story. Judge Simpson methodically walks through each file, ensuring accuracy. This isn't speed, it's precision. Retail fraud cases stack fast, and here we see the cumulative effect. No contest pleas protect against civil claims, but sentencing exposure grows with each count. The judge ensures the defendant understands maximum penalties for each charge. Engagement question. At what point do repeated misdemeanor cases start to feel like something more serious?
I am happy to do that. Your Honor, chart 22410696, the defendant will plead no contest to this charge to retail fraud in the 2nd degree.
Hang on, which case?
696.
696, he's pleading no contest
As charged.
as charged. All right, got it.
698,
Yes. He's doing what?
no contest to an added count for retail fraud in the 3rd. Dismiss count 1, count retail fraud 2nd.
That's no contest to that charge
Yes,
also.
Your Honor.
They're all no contest
Yes, Your Honor.
from the reports I read. Okay, I hope they are. All right. Go ahead.
697,
Yes.
he'll be pleading no contest to an added count to a retail fraud in the 3rd degree, dismissing count 1 retail fraud in the 2nd degree.
Okay,
328,
yes.
he'll plead no contest is charged to retail fraud in the 3rd degree.
Okay,
And lastly, 278,
yes.
he'll plead no contest to an added count to a retail fraud in the 3rd degree, dismissing count 1 retail fraud in the 2nd degree.
Okay,
Case 699, and don't plead, the dismissal cases now, 699,
700 and 2419, and then 218 would be dismissed.
that's correct. Restitution for all cases and all counts.
So basically, he's pleading to 5 counts of retail fraud 3rd degree.
1 retail fraud 2nd, 4 retail fraud 3rds.
Okay, hang on a second. Got it. Okay, in 696, he's pleading to retail fraud in 2nd degree.
Exactly right, Your Honor.
Why, I don't know, but is that correct? Is that a correct statement?
Yes, it is, Your Honor, and that is what I discussed with my client, and that is what he would like to do today.
All right, Mr. Allen, raise your
Yes,
right
sir.
hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name for the record, please, sir.
Jason Allen.
All right. Mr. Allen, it is this court's understanding that you are going to be pleading no contest to 1 count of retail fraud in the 2nd degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that, sir?
Yes, Your Honor.
And that also you'll be pleading no contest to 4 charges of retail fraud In the third degree, those are misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would be the maximum fine. You understand that?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, Your Honor.
All right, 2 things about a no contest plea is that I have to make sure that you understand is that first of all, it means that you're not further desirous or wanting to contest any of these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea in these cases?
Potential civil liability, Your Honor.
All right. So, sir, to the charge of retail fraud, second degree, how do you plead?
No contest, Your Honor.
To the charge of retail fraud, third degree, as contained in the case ending in 698 with an offense date of March 12, 2024, how do you plead?
No contest, Your Honor.
To that same charge of retail fraud in the third degree, contained in the case ending in 697 with an offense date of March 17, 2024, how do you plead?
No contest, Your Honor.
To the charge of retail fraud, third degree, as contained in the case ending in 328 with an offense date of 8/29 of 2023, how do you plead?
No contest, Your Honor.
To retail fraud, third degree, as contained in the case ending in 278 with an offense date of November 27, 2023, how do you plead?
No contest, Your Honor.
All right, now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct, sir?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
All right. Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am a participant of Judge Kunke's drug court.
All right, so you're on probation. Well, were you on probation at the time of any of these offenses?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will?
Yes, Your Honor.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report in the case ending in 696, the report number 23-14001. In the case ending in 698, the public safety report and case number 244086. In the case ending in 697, court has reviewed the police report 244362. In the case ending in 328, court has reviewed the police report and police report case number 23-12936. And in the case ending in 278, court has reviewed police report ending in 2318100. Since I've read all those, counsel, is there any objection to the court having reviewed those reports?
No, Your Honor.
No, Your Honor.
All right, the court in each of those reports does find a sufficient factual basis in which the court could find the defendant guilty of the offenses as alleged, or sufficient evidence of defendant's guilt in those cases. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas in all of these cases to count 2 or to retail fraud second in case 696, and in the other matters to retail fraud third. The other cases, as indicated on the record, are no longer with me. Those matters are dismissed. All
Thank
right.
you, Your Honor.
Defendant is referred to probation for pre-sentence investigation and report. sentencing in these matters will be June 25th, 2025, 9 a.m. Defendant's bond in all of these cases will continue. Mr. Allen, I need you to wait online. We're going to put you into a breakout room with my probation department
Sure,
so
thank
that
you.
we can begin the sentencing process. Okay, sir?
Thank you, Your Honor.
Thank you.
Thank you, Mr. Allen.
Thanks, Natalie.
This courtroom session shows the justice system in full motion. Efficiency, discretion, accountability, and restraint. We saw first-time offenses handled with conditional trust, repeated absences met with warrants, and multi-case defendants facing consolidated consequences. Judge Simpson consistently emphasized understanding, voluntariness, and procedural correctness. Pleas were accepted only when the record was clean. When uncertainty appeared, proceedings stopped. That's how courts protect legitimacy. The broader lesson is clear. Outcomes aren't just about charges, they're about preparation, honesty, attendance, and timing. Court rewards clarity and punishes chaos. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.